you might think twice a little bit. Burger King, in its 2012 case, did fire the employee, an employer, or supervisor for the social media post, and they got all that info from the barcode on the lettuce container. So it's pretty amazing and kind of sad. In the last 2 years, when people get bored on the job, I don't know. But when they do get fired, what do some folks do? Depending, right? Some of them do all kinds of stuff, just hide. Some of them will file discrimination complaints. Meet Mr. Roberts, who worked at IBM, and shelf life. This is called the shelf life case. Does he look like shelf life to you? I don't know. Well, they referred to Mr. Roberts at IBM as shelf life in a situation where they were actually firing, laying off people, a reduction. The company's HR managers discussed Roberts as shelf life via instant message conversation, IM. Roberts was fired and was sued under the APEA, saying that shelf life was a comment that was direct evidence of age discrimination. The 10th Circuit affirmed the district court's grant of summary judgment to IBM, finding that the comments, given the context, were not related to age, but rather to the quantity of billable work Mr. Roberts faced. I don't know what you think about that, but I think shelf life might not really refer to his billable hours. Anyhow, that's what they found. We move from there to disparate enforcement of social media policies. So, you know, we all do stuff online, and we try to, you know, keep it private as much as we can. But this is a Wells Fargo case, Williams versus Wells Fargo 2008, during a quality assurance review. Wells Fargo discharged 31 employees, 30 of whom were African American, for sending sexually suggestive and otherwise inappropriate jokes or pictures. While the court denied Wells Fargo's motion for summary judgment, Caucasian employees forwarded similar inappropriate pictures, but they were not immediately terminated. So, disparate treatment. Let's go to my space, your space, everybody's space. Marshall versus Mayor of the City of Savannah, 11th Circuit, 2010. Anybody heard this case? Tammy? My space. What did this firefighter do? This female firefighter, this doesn't say it here, but she actually posted photos of herself, sort of semi-nude, online on her MySpace. And she was trying to promote the modeling of firefighters, that firefighters should model outside of their jobs. So the employer found out, and of course the nice way to put it, they're inconsistent with the city's image. And during the investigation, the employee, she allegedly said disrespectful things to her supervisors and complained that other employees had similar photos. So her employer terminated her for insubordination and violating the policies, and she filed a disparate treatment claim. The 11th Circuit upheld the dismissal of her disparate treatment claim because Marshall, she couldn't show that her employer knew about the other employees' website postings. So, note to self, don't post semi-nude photographs of yourself if you're a public employee. And especially not with a MySpace or any account with your actual name. Don't do it, but if you're going to do it, don't do it with your name. Retaliation claims, okay. Although employers can monitor employees' social media use, they should pay careful attention to temporal proximity of employee complaints. So, you know, we get online and, you know, the first thing we see is everything the government can monitor, correct? Right? And yes, you agree that we're going to monitor, we can monitor everything we do on this computer. And that's true. But yes, note to self, if you're an employer and something's going on, EEO case, you may not want to monitor that activity just too closely to the EEO complaint, right? Temporal proximity, retaliation. A New York 2008 case in which the employee was able to amend her complaint to add retaliation claim under New York sexual harassment law. Ruling internet monitoring can constitute retaliation, the court found, quote, in consequence, I cannot foreclose the possibility that a trier of fact reasonably could find that defendants alleged covert monitoring of plaintiff's personal internet use at work might well have dissuaded a reasonable worker from making or supporting a charge of discrimination. The court did note that the extent, nature, context, and motivation for the alleged monitoring would be determinative. So temporal proximity exists everywhere. This is, I'm going to skip this slide for a second here. Moving on to confidentiality clauses being breached in settlement agreements. We all deal with them. And of course, in this case, we're going to, we're looking at settlement agreements of EEO claims.
That's my middle school in Florida. Really? Yeah.
You went to school there, Lisa?
I went to middle school with Oliver.
Oh my goodness! So then, do you know Miss Snake?
I heard about this case, but I am a little older than her, so.
Do you know Miss Dana Snake? She went. This is a college student. Oh my goodness! And these pictures, by the way, are pulled from articles that were published online. Okay, so this is not just a I don't know Miss Snake. I didn't ask her for a photograph. What did Miss Snake do? Go over school. Her parents settled age and retaliation lawsuit for $150,000. Pretty decent, 2014 case. The release agreement contained a confidentiality provision, which we've all seen in hopefully in all of our settlement agreements. Days after the agreement, the college-age daughter posted on her Facebook wall, and I'm not going to do, hold on, let me see if I can do this. Wait a minute. What did she say? Because I have to read it to you while I'm looking at her.
Mama and Papa won the case against Oliver. Oliver is officially paying for my vacation to Europe this summer.
There you go. And it was posted to 1,200 of her Facebook friends, including current and past Gulliver students. So what happened, Gulliver, they paid the attorney's fees of the settlement agreement, but they withheld Snake's portion because of the breach. And I believe we're talking about like $80,000. Yeah.
Was that the caption under that picture she posted? Because that would be funny if there was.
What?
Yes.
No,
She
it
posted that picture
no.
and put that caption under it?
No, that was my caption for her. Because I wanted you to get a visual of this lovely young woman who probably didn't realize that this 1,200 Facebook friends, somebody in there was going to be part of Oliver, yeah? So, and you left out the best part, but I won't repeat the last 2 words there. Okay,
Yeah.
You can read. The post was visible. They lost like 80 grand. The court upheld the dismissal and said his daughter then did precisely what the confidentiality agreement was designed to prevent, advertising to the Gulliver community that Snake had been successful in his age discrimination and retaliation case against the school. Yeah, Miss Snake. All right. Next one, offensive use of social media, FMLA, and likewise transferable to disability claims. Linberry, is it Lynn or Lineberry? Lineberry versus Richards, 2013 case, Eastern District of Michigan. Anybody heard of this case? Tammy? Okay, all right. So what happened here? She was on FMLA leave. She had a planned vacation to Mexico. And I'm going to do this because I want you to get the visual. She posted pictures on Facebook, including shots of her on a motorboat, holding beer bottles in her hand. Her post there says, "Dos cervezas, por favor." And then her coworker said, "Oh my God, you're scaring me with posting these things because of her injuries." I mean, you don't just get on a motorboat if you've got these extensive injuries. When confronted with the picture, she claimed that she used a wheelchair during vacation, but she later admitted to lying. So I'm taking a wheelchair on the motorboat. I mean, did you guess?
No, go ahead.
I have 5 minutes? Oh, great. The employer terminated her, and they had legitimate reasons for its decision to terminate her. Okay, good. So I'll just skip. The next case is very similar, 5 more minutes. 6th Circuit, 2012 case. She said she was completely incapacitated. Miss, I can't pronounce that name. If anybody can, Mrs. J. But she was actually at a festival drinking beer and having a good time. Okay. Offensive use harassment claims, EEOC versus doing business as literally IHOP. This particular situation, the employer tried to defend by saying that although at work, her boss literally tried to IHOP her. I mean, gives new meaning to the word IHOP. He did some strange things at work, very sexual, physical in nature. But they tried to defend by saying, well, look, she shares jokes with friends online, and she makes sexual jokes. The court found that wasn't good enough. Sharing jokes with friends online is vastly different than being propositioned for sex by a supervisor at work, and they upheld the jury verdict. Okay, so now moving now there are cases with regard to potential discrimination claims in terms of the hiring process. or the GINA. But this is something that, again, is coming. We can just see it coming. Although we as the government don't necessarily, recruit via online. I mean, who's going to say that when you've got lots of people that you're trying to distinguish against, checking references, whatever, it's so tempting and so easy to check everything online, And so employers in the private sector say that these are, kind of shows you here, what are they looking at when they look at you online? And I don't care who you are hiring, illegal drug use, tweets of a sexual nature, profanity, reference to guns, pictures of alcohol consumption, all of those things are negative. Neutral, however, religious posts, political posts, and positive volunteering. Very nice. Okay, these are 2 cases that deal with this. All of this information will be on USDA Connect, the full. I have a 30-page outline, so you can actually read all the cases. But Mr. Gaskell didn't get hired at the University of Kentucky because they read that the university sent emails saying that we don't like his religious beliefs, therefore, and they actually put it in print, and so they didn't hire him. Let's see, and potential ADA and GINA hiring claims, again, these are coming. Genetic Information on Discrimination Act. What if somebody finds out you've got cancer, or you've been diagnosed, they see a post online? What does that open the door to? It opens up to a lot. Let's see here. Disparate impact. In hiring, something to think about. Caucasians and Asians are overrepresented on Facebook and LinkedIn. African American, Hispanic internet users, twice as likely as Caucasian internet users to use Twitter. So very interesting in terms of maybe more men than women, maybe more this, 3 minutes, okay. Maybe more, of one category than the other. And so when you're recruiting, and if somebody finds out, social media, LinkedIn, disparate impact of age, those who are 45 and over are half as likely as those in the 26 to 34 age range to use LinkedIn as a professional profile. So you're just not out there, Potential disparate impact hiring claims. The EEOC says the majority of Facebook users are under the age of 40. If employers recruit applicants through social media, older workers could claim the practice disproportionately excludes candidates based on age. I'm going to skip this one here and tell you how you can protect your social media self. How can you do it? Go to some of these websites. Many of them will show you how to set your privacy settings and investigate the online accounts of people that you know. Even if you don't have an account that you actively use, how about your daughter, your niece, your nephew, Miss May over there, right? How can you make sure that your image is appropriately being used, or how you can block it? So that you don't have to deal with issues that you don't even know are out there, unfortunately. Here's my contact information. I have some cards here on the table, lots of handouts. Everything that you see here today is going to be uploaded and available in the next day on USDA Connect. There's a website. EOF required to go in and you'll find the folder that we have there on this particular presentation. So thank you all. If there's a question, I'm told I'm out. Yep.
The case that you were talking about, the individual with the, I can talk loud. The case you were talking about, the individual in the firefighter uniform that was doing the inappropriate pictures, did she win, you said? I guess it blew over my head.
No,
She did not.
she did not.
She shouldn't have done it, right? Yeah, it was because she was in uniform, right? Okay, I just wanted to. And then I wanted to go back to one more thing.
Sure.
I guess I really need to understand her, I'm sorry, I don't remember your name. Point about, how you should address someone. Are you in reference if you've seen them? Is that what?
I was asking for both situations, if you've never seen them or in person. In a formal setting, obviously sometimes you sort of a ma'am or address letters in the way. So I wanted to know how that.
Okay. I guess to me, I just couldn't understand how does it come up? You know what I mean? If you maybe talk to somebody on the phone, it's not, I guess, discriminatory or negative if I don't know. You know what I mean? If I'm a female on the phone, it sounds like a female voice, then I would say she. If it sounds like a male voice, I would say he. So,
Yes.
right. Really? Okay.
A situation where people are referring to themselves in a way that you may feel is derogatory or that makes you uncomfortable. For example, I worked in an organization where a group of people would refer to themselves as rednecks or good old boys. And I was uncomfortable with those terms because depending on who you speak to, it can be derogatory, it can't be derogatory. So my official position as the equal employment specialist in that organization was some terms just are not appropriate for the workplace. I don't like that term redneck. It's just too controversial. So what about that? What about when people are referring to themselves in a way that it's just going to be controversial?
I think we all have an opinion, but.
Yeah, I think you handled that very well. I mean, I think people often use, they'll tell ethnic jokes about their own ethnic people. People will use derogatory terms, and sometimes they're doing it to reappropriate the symbol of their oppressors. So there's that whole school of thought. But I think in the workplace, a lot of that can be addressed through training. We can talk, do diversity training and talk about how terminology affects different people and having open dialogue about that. I think having a policy where you don't use any slang or slurs, it's pretty hard to enforce that. But I think if you do have a specific situation, it's always a good, either you hold a group training on diversity so that nobody's singled out, or if you really have a serious problem between two employees or a group of employees, that's what our workplace dispute resolution is for. You can sit them down with a third-party neutral and talk it out and have people understand. But if it rises to the level of being harassment and creating a hostile environment, not necessarily for themselves, but for the people around them, then you have that avenue as well. So it could be a misconduct issue or a discrimination issue. So really, again, that's going to be very fact-specific.
All right. Thanks for staying for my last presentation. If you need to stretch your legs, I'm not offended at all. So please stand, and you can even move over here if that's more comfortable. So my name is Layla Levy. I am on the board of the Hispanic Bar Association of the District of Columbia, and I was on the planning committee for the Hispanic National Bar Association conference that happened this past September. So part of that conference, we had a continuing legal education course on minorities in higher education and affirmative action as a result of the most recent 2012 and 2014 Supreme Court cases. So before, I just want to talk about the ground rules that Ashley alluded to earlier. This is a controversial topic, and asking the questions doesn't make you look stupid, it makes you look smart, because you can't learn unless you ask a question. So please do ask questions at the end, and make a note of whatever questions you do have. So to define affirmative action. Affirmative action means taking positive steps to increase the representation of women and minorities in the areas of employment, education, and parts of our culture that they have been historically excluded. So we all have been talking about the employment context most of the afternoon. I'm actually going to focus more on education, but a lot of this issue crosses both sectors, employment and education. So those steps will involve a preferential selection, and of course this is where the controversy comes in, right? A preferential selection on the basis of race, gender, or ethnicity. An example would be a law that requires someone to interview the number of women in proportion to the number of women applicants for a job. That's in an employment setting. Comparing non-discrimination and affirmative action in a civil rights office is also helpful. You see that a law that states that employers and schools cannot discriminate is not actually an affirmative action law, although the goals may be similar. Affirmative action is not the same thing as a quota, although a hiring quota can be a form of affirmative action. That's an example of a quota. 10% of the school students must be disabled or African American